the session. Terrific. And Kate, if you agree, I'll start, and then folks will trickle in as we commence the program. So welcome everyone. Good afternoon or good evening, depending on where you are, or good morning. And welcome to Foreign Government Censorship Policies, Challenges for U.S. Businesses. I am Michael Tudori, president of the Washington Foreign Law Society. The Washington Foreign Law Society was founded in 1952 to promote knowledge and understanding of international and comparative legal issues in foreign law. We're a nonprofit organization based in Washington, D.C., which serves as a forum for discussion among legal and non-legal professionals serving in public and private capacities within a diverse range of organizations, international organizations, law firms, the U.S. government, foreign missions, NGOs, academic institutions, and private sector companies. Today's session will be moderated by Kate Linton. Kate is a senior attorney advisor at the U.S. International Trade Commission and a board member of the Washington Foreign Law Society. A couple of quick housekeeping notes before I let Kate introduce all of our terrific panelists today. You can use the Q&A section, Q&A feature at the bottom of the screen to send us questions. We already received a number of questions from the audience, but if you have more questions, just please use that function, and we'll get to that at the end of the session. The session is being recorded. So all prior recordings of the Washington Foreign Law Society are available on our website, wfls.org. So I encourage you to take a look if you haven't already. And finally, don't forget to follow us on Twitter and LinkedIn. Our handle on Twitter is @WFLS1952. One very final note, do consider becoming a member of the Society. There's a discounted rate for students and government nonprofit employees. I'll be putting a link on in the chat if you're interested. That being said, Kate, the floor is all yours.
Great. Thank you, Michael. So this program tonight, the obligatory dog bark, this program tonight arises out of a report that was issued in January of 2022 by the U.S. International Trade Commission, an independent agency. It's the first of a two-part report that's focused on foreign censorship policies and practices and their impact on U.S. businesses. The first report, which was requested by the Senate Committee on Finance, highlights censorship-related policies in 6 key markets: China, Russia, Turkey, Vietnam, India, and Indonesia. The second report will be issued in July of this year, and it will focus on the impacts of those policies on U.S. businesses. Before we dive into the program, I'd like to take a moment to recognize that a lot has happened since we issued this report in January. On February 24th, Russia invaded Ukraine, and we're now in the 5th week of this terrible war. On March 4th, Russia banned what it calls fake news, including calling the invasion an invasion, and threatened long prison sentences for violators of the law. Many foreign and domestic media outlets have been shut down, and some social media platforms like Facebook, Instagram, and Twitter have been blocked. We will talk about this latest development in Russian censorship later in the program. But we'll begin with a summary of some of the main findings from the report by Martha Lawless. Martha is the head of the Services Division, and she oversaw the preparation of the report. After that, we'll turn to Nigel Corey from the Information Technology and Innovation Foundation, then to Ali Funk from Freedom House, and finally Daphne Keller from Stanford Law School. All 3 provided the ITC with invaluable contributions to the report and are experts with different perspectives on the topic. We'll also respond to some of the questions that were provided to us ahead of the time, and time permitting, those in the Zoom Q&A. So Martha, would you get us started by just summarizing some of the main findings of the report?
Sure. I'm really pleased to be able to present the report to a wider audience. I think it is exceedingly timely, as we were talking about earlier. The report focuses particularly on censorship in the online environment, because when we thought about it, the digital and non-digital media sectors, the audiovisual sectors, that's movies, video, TV, books, as well as social media and internet search, those are the arenas in which censorship is most operative. So we focused on that. So to start, what was the scope that we included in addressing the request that we were given by the Senate Finance Committee? And that was to describe policies and practices that were directly suppressing speech. And those included laws that target certain categories of speech or pre-market review of certain content like movies, internet shutdowns, or internet blocking, filtering, and throttling. The other category of policies that we looked at and we included in our discussion were those that enable or facilitate censorship. And these are things like internet intermediary rules, data localization requirements, local presence requirements, as well as certain market access and foreign investment restrictions, particularly for the sectors that I mentioned. I need to emphasize that there was a lot of emphasis on this not being, these policies are not necessarily censorship policies as such. They're not automatically, but they are in certain instances censorship enabling. They may be because a government requires an internet intermediary to comply in an unreasonably short length of time, making it impossible for the speech to be presented. Or there are other examples, for instance, a local presence requirement where we can just go to the local office and intimidate the employee. So those are the policies that we looked at. We did not include in the discussion things like intellectual property infringement rules, because those have well-established sets of rules to handle those. Because we're talking about government policies, it's typically discussing a domestic jurisdiction, their domestic policies and oversee operations of firms in that country. But we also looked at extraterritorial censorship, and that can come either because the firm's speech or presentation of content is affected globally by the censoring in one market, or it can be that the speech is somewhere outside the market, but because the market's so big, read China, they're able to use leverage because of the operations inside China. So the policies were also, we looked at who was doing them. So it's not just governments, but it's also the private that implement and enforce these policies because of the system of how digital services work. So firms have to act at the government's request or by requirement of a government, but they can also act by self-censorship. And that was one of the areas that the Senate Finance Committee was also interested in. So where is censorship a big problem? Which are the markets that we identified? The top 6 that we look at are China, Russia, Turkey, Vietnam, India, and Indonesia. And these are in rough order of severity in terms of censorship. We selected those 6 markets because they met 2 criteria. The first one was that censorship is significant and pervasive in these markets. There's filtering of information on a range of topics, whether they be political, social, or national security topics. And they are implemented in a way that US firms operating in the market already or wanting to operate in those markets are affected significantly. The second criteria is that the market opportunity for US firms is big enough to make the discussion of first rank order. So we didn't discuss at length markets where there's very intense censorship, but it's just a very small market. So we did concentrate on larger markets and on markets that are where the censorship seems to be impactful and does not fit within the norms of international human rights law. These 6 markets, they all 6 employ the full range of tools that they've got to implement and enforce censorship. Some countries do different ones more than others. There are particular differences, but they all intensified their censorship and used a wide range of censorship over the window that we looked at, which was in the last 5 years, with a little bit of an earlier look as well in certain countries. So I think I'll leave it there and we can come back. Kate, you're mute.
Classic. That was great. Thank you, Martha. I wonder if you could just for a minute address, Martha, one of the questions that came to us by the audience ahead of time. That is whether countries' gamut of censorship policies resulting in creators dumbing down their speech to avoid punishment. As you mentioned, the ITC made some findings in the area of self-censorship. Could you speak a little bit on that a little more?
Sure. So it was explicitly requested that we look at both self-censorship and extraterritorial impacts. So we did some investigating on that. Self-censorship is when a firm changes, adjusts, removes, edits content in order to avoid. It's precautionary, right? So that is a very, very strong response. Lots and lots of firms let us know that that's what their practice is when the market is, the government in that market is particularly censorious. So if as the government requirements become more intense, there's more self-censorship. It just makes sense for the firms to do it in a more organized way, thoughtfully, and in conjunction with their plans around the world. But it limits their business opportunities, and it also can add costs because they have to do all of this internal decision making. The fact that it is internal decision making, that it's difficult for outsiders to observe self-censorship because it's part of the product design phase, and it's also part of the distribution planning phase. So you don't go and say, oh, that's a self-censorship event. But you do see it by reporting afterwards in certain cases. I think the question was targeting the idea of whether there's a compromise of content by having firms do this self-censoring. And we heard that does happen in some instances, but there was more a focus on just that the whole effort is very costly and complex, and that sometimes the firms did it, they changed the content, and they didn't feel it made that much of a difference. It was just that they had to go through the exercise of changing the content.
That seems like a good lead into talking about China some more. So Nigel, first, thank you. I know the ITIF provided us with a lot of information. I'm wondering if you could talk a little bit more about how censorship works in China, the Chinese regime, and also how it interacts with market access and FDI restrictions.
Yeah, no, happy to. Firstly, thanks for the opportunity to further talk about what a lot of us have contributed to and what is really quite an interesting issue given developments that have happened in the interim. And it's a very new issue to try and, for the US government as well as others, to try and address. So it's quite interesting to try and figure out where the lines are. But China and censorship and market access sort of all go together in a way that is unlike any other country, really. China's a world leader in using censorship as a market barrier. It long has for over 2 decades, obviously starting or most clearly symbolized by the Great Firewall of China, which blocks thousands of websites from within China. And it's not just, they use that not just to target sort of specific pages that they find offensive or illegal, but they use it to just block at the core sort of foreign service providers that otherwise should or would be able to access the market. But it's much more than just that, in that it's much more than just their overly broad blocking of websites. There are arbitrary, opaque, and discriminatory content review processes for TV shows, movies, apps, software, video games, and other digital content. China's long had a strict and very small quota on certain foreign content, such as sort of blockbuster movies. There's also arbitrary, opaque, and discriminatory licensing control over internet content distribution, internet access, and internet connectivity services, such that it allows them to enforce internet blackouts. It also, in a related way, enables them to enact strict control over potential circumvention services like virtual private networks. And then obviously there are local data residency requirements whereby they force firms to store data locally, in part so that they can use that as a cudgel for content moderation frameworks that ensures that they can identify content that they find objectionable and illegal, and that they can hold someone there legally responsible for it, thus sort of making it easier for them to sort of build out their censorship regime. And the problem with China is that it has been doing this for a long time, but the apparatus has grown and become more sophisticated over time. And at no point did it really face much concerted, coordinated opposition. So it obviously pushed and pushed and pushed and realized no one was pushing back. And so they were able to develop a very broad censorship regime that now represents the worst in class in terms of a model globally, which is what we're now seeing is hugely problematic because other countries are looking to China for ideas and tools as they themselves consider their own content moderation / censorship regimes. And so, but what this has done from a trade and economic perspective in China is that it means that there's a generation of Chinese consumers that have grown up with a fundamentally different internet that we here in the United States, as well as most other people in most countries around the world, have grown up with. Because their censorship regime has kept out a lot of internet providers, obviously news providers, video game development agencies, obviously movies, TV shows, all the streaming services all of us have been surviving on during COVID don't exist in China. And all of that directly and indirectly is related to their censorship regime, but obviously all of that has a very large impact on the ability of content creators and other firms to engage in digital trade and connectivity and communication in China. And again, that is hugely problematic, but it becomes even more problematic as we see other countries sort of taking leaves out of their books in Vietnam, in Indonesia, India, Pakistan, Turkey, and elsewhere. And so that's why I'm glad the study has been done, and why hopefully the Biden administration and Congress will consider this great report and figure out what comes next, because without more concerted action, unfortunately, China's approach will become more normalized and obviously would like to see. And so those countries that respect an open, rules-based global digital economy need to do much more to provide clear guidance and clear frameworks and principles and clear red lines for how countries should manage content online, such that censorship or content moderation, however you want to phrase it, basically inhibits a broad range of trade online. And I'll end it there, and obviously happy to talk further with the Q&A.
That was really helpful. Nice overview. Thank you, Nigel. You did touch on one of the questions that came from our audience about the exporting of China's model to other countries. Do you have any mention of number of countries? Could you provide an example of what that might look like in your view?
In contrast to how some folks characterize it, it's not so much an export and copy and paste of a model. As far as I've seen, it's more I take China's approach as more a buffet, in that what's tended to happen thus far is countries that often have an existing authoritarian sort of streak to their politics are naturally attracted to what China does in terms of its strict control over content online, and thereby look to it for ideas. And so we've seen examples of that in Indonesia, in Vietnam, I should say, as well as Indonesia. A more recent case involves Tanzania, in whereby China and Chinese firms were involved in building out ICT infrastructure in Tanzania, including data centers. But then obviously as Tanzania considered content moderation frameworks online, they were also drawn by proximity and by connection to what China has done. And I think that is an example of what we'll see more of, in that in many countries, especially developing countries, where China and Chinese firms have stepped in to deploy much needed, I should say, ICT infrastructure, there will be a second wave of regulatory or policy engagement that stands the chance of also replicating China's approach. And that's very problematic, because it's one thing to build out infrastructure that can then be used in any which way. But if on top of that, there's a regulatory framework that is more akin to China's approach to managing content online and engaging in censorship, then that's obviously going to be hugely problematic. But yeah, so those are some of the more recent examples. I mean, but you see, it's even second and third order effect, right? Like India is attracted to China's model and strict control of content online. But then you see in other countries like Pakistan looking at India's approach, and Bangladesh looking at India's approach, and Sri Lanka. And so you have this sort of ripple effect as countries themselves eventually turn to figuring out what they want to do. They look to their regional neighbors and then maybe also look to China. And if they're all heading in a generally similar direction, then it's going to be hugely problematic.
Thanks, Nigel, and thanks for bringing in some of those other countries. Ali, I wonder if you could actually talk to us a little bit about some of the other markets that Martha mentioned: Turkey, India, Indonesia, Vietnam. And I think what she said is that they've been recently passing new laws and engaging in some concerning practices. Do you have a sense of sort of the most important things you're seeing in some of those countries that it would make sense to provide?
Yeah, first off, thank you so much everyone for having me. It's a great report and I'm excited to get to talk about it today. So governments sort of around the world, and not just the four you mentioned, but even more broadly, have moved toward trying to force tech companies, and here I'm thinking about the social media platforms, streaming platforms, and depending which law you're looking at, some are more narrow, some are quite broad, to censor more categories of speech with limited safeguards. So the four you mentioned, India, Indonesia, Turkey, Vietnam, all have very different political and internet freedom contexts, Vietnam being the most restrictive of the four. But what's interesting is that all four over the past few years have rolled out these new censorship legislations that have very, very similar provisions. And I want to flag sort of three parts of it that I think, and that Freedom House thinks, are some of the most concerning ones. First, it's how many laws are criminalizing these just really broad categories of speech, and then requiring companies to remove that content under really tight timelines. So if you're looking at Indonesia, they have Ministerial Regulation 5 is what it's called. So it requires platforms and other sort of online marketplaces to remove speech in what the law defines as, quote, urgent situations in only 4 hours of being told to. And then in non-urgent cases, it's 24 hours. And just this week, I think Reuters reported that there are new rules to come out this summer to help clarify how that law is going to be implemented. That's going to include fines and criminal charges against companies if they don't follow those timelines. And in the Indonesia market, the law mentions, violating domestic law, creating community anxiety, disturbing public order, these really broad terms. And when you're looking at the Indonesian context, that often sweeps up or specifically targets LGBTQ plus content. So, looking at how companies would comply with these tight timelines, they're really incentivized to deploy these automated monitoring systems that often excessively or inconsistently flag speech. And most often, the way these systems work is that they're disproportionately flagging the speech of marginalized communities. So speech that may not be in a dominant language that the system was trained on. So, in India or Indonesia, if it's a Papua community, that might speak a more indigenous language. And then these systems are also can be really costly and resource heavy to do. So by requiring them, it means that smaller and newer companies have a harder time complying with them. So it can be actually further submit some of the big players in the market. The second provision that I want to highlight relates to requiring companies to open up in-country offices or having local employees. So looking at Turkey, the Turkish example, back in 2020, there's a social media law that was passed that requires a Turkish national to be appointed as an in-country representative or company to have a local legal entity. And what these local presence do is it creates a new leverage for the state. So government officials now have a physical location or a person that they can show up to and tell them, hey, we want the company to act in this particular way. And the Turkish government's working on another draft social media regulation law currently that is going to further criminalize, I should say, the spread of what the government determines to be disinformation with up to 5 years of imprisonment. So mixing sort of the local representative requirements of the previous law with the criminal liability of the new draft law, it's going to curb companies' willingness to push back against state censorship requests. And I will say this isn't just theoretical. This has already played out in Russia a few times. One of the big examples that folks sort of in the internet freedom community are talking about was last September when Russian agents showed up at a Google employee's home and threatened prison time if Google did not remove the app of opposition leader Alexei Navalny's smart voting app during legislative elections. Google then complied, so did Apple. So it's not sort of a theoretical situation about how these local presences play out. Then the last provision I just want to add in the laws in Vietnam, India, and Turkey, and many others around the world too, are requiring data localization, which just means that companies must store data, user data on servers in the country. So this presents, pretty serious privacy concerns. So, in countries with poor human rights records, domestic data storage can expand the risk of surveillance, but it also presents censorship implications. So data localization can be really expensive and really onerous for companies to comply with. So some governments will just use the threat of passing localization, or when localization is already passed and maybe not enforced yet, they'll use the threat of enforcing it to get a company to comply with censorship. And that's what some of us think might have happened in Vietnam when Facebook a few years ago agreed to censor speech that was critical of the ruling party after Vietnam sort of throttled access to the platform right a few years after the country's cybersecurity law was passed, which has these requirements.
Thanks, Ali, for that overview. One of the questions that we got from the audience was just about how there can be so many different motivations, so many drivers for censorship in different countries. Could you discuss in these countries what seem to be some of the primary justifications or motivations behind censorship?
Yeah, it's a great question because there's a lot of different motivations and they kind of all intersect, and it's hard to sort of weave them out because these laws are complicated, the political contexts are complicated, so there's not always an easy answer. But there's similar motivations behind the 4 countries I just mentioned and some of these laws more broadly. So some, can be good faith attempts to mitigate sort of harassment, hate speech, disinformation. But many of the laws deploy sort of what on paper seems like innocuous language or broad or vague language that can then both sweep up going after legitimate disinformation and harassment, but also be used to go after political, social, and religious speech. And what I have found interesting throughout the years, and what I think the report gets at, is there's been a shift. It's not just authoritarian governments that are doing this, China, Vietnam, Iran, Saudi Arabia, Russia, but it's these established and backsliding democracies like India, Indonesia, that have realized that they can use platforms' power for their own political ends. And, this includes censoring the speech of, that's critical of powerful political or business leaders, wanting to suppress people expressing their religious or sexual identities, or, in a lot of countries, they might want to be limiting how marginalized communities can speak to people of that same community who are based abroad. And I think India is really a perfect example of this. It's often called the world's largest democracy. And over the past few years, the ruling Hindu Nationalist Party has just been on this like fierce campaign to remake the internet in what I call in its own image. And the country's IT rules that were introduced last year require large social media companies to police content that undermine public order, morality, decency, and then the country's sovereignty and integrity. So similar terms, like I mentioned in the Indonesia law earlier. And at first glance, you might think, oh, in a democratic country, that doesn't raise immediate alarms. But if you look at the broader context, the rules were introduced in the midst of the ruling party having this showdown with Silicon Valley. And Twitter had just resisted government demands to censor content from activists, journalists, and opposition figures amidst these mass protests against agricultural reforms. So the political motivation is quite clear when you look at the bigger picture. And then the other part of India that I actually find really interesting that happened probably a year or two before the government turned its eye towards some of the bigger platforms, the big tech platforms, was how authorities were going after the streaming platforms like Amazon, Netflix, and the Disney's platform as well, particularly to try to limit content that was criticizing or insulting Hinduism and criticizing the government's approach to what they were doing in Kashmir. And what that's meant is that a lot of streaming platforms now actually just proactively self-censor content and take out scenes, take out episodes because they're fearful of criminal penalties or from harassment of pro-government supporters. So I'll stop there because I could go on for India for a while.
No, that was really great, really great. Thank you. Let's shift gears for a minute, if we could, to Daphne Keller from Stanford. In your testimony to the ITC, you talked a fair amount about the difference between speech that is taken down for violation of a national law on the national version of a platform, as opposed to speech that's taken down globally because it violates a company's terms of service. And you also spoke about the sort of increasing informal pressure that governments are putting on platform companies to take down speech themselves globally under their terms of service. I wonder if you could talk about these blurry lines between platform conduct and government conduct and sort of how we should understand this in the censorship realm.
Sure. So I just want to start by really thanking Kate and Martha and all of the ITC people who worked on this report, which is so thoughtful and thorough and careful in an area that often has a lot of maybe Sturm und Drang and not so much care and thoughtfulness. So everyone should really appreciate this report. And I also think a really important thing about the report is its focus on how censorship efforts just work differently when they're based on enforcement against platforms instead of enforcement against publishers. Because if a government agent or a lawyer with a scary letter comes to a publisher and says, stop publishing this, and the publisher thinks they have a right to publish it, they're probably going to fight for their right to do so. They have much more incentive and ability, and probably this doesn't happen too often to them. By contrast, if it is a platform, if it's Twitter or Google, where I used to work, or Facebook, receiving that same kind of legal pressure, they might fight back and stand up for the user's speech rights. In fact, in many cases they do, but their incentives are just very different. It is much easier for them to just say, fine, I assume this is illegal, I'm gonna take it down. Why would I spend my time or money fighting for this particular user's speech when there are a billion other tweets out there? And so just the amount of collateral damage that is done to lawful speech once the enforcement is against platforms instead of against publishers is significant. So it's great to make that part of this. This relates a lot to your question about jurisdictions and cross-border enforcement. So just sort of to summarize, most of the big platforms, certainly the ones that I just mentioned, have essentially two systems for when they take down content. The first is if the content violates their own discretionary terms of service, their house rules for speech, they'll take it down globally. And the second is if it is permitted under those house rules, but it violates local law, like posts about the Hells Angels in Germany, for example, then they will take it down just on the nationally targeted version of the service. So, the German version of Facebook in the Hells Angels example. That is a relatively long-standing system, but the legal compliance part of it is a nuisance. It takes time and money to pay local counsel to figure out if there is a legitimate legal reason to have to take something down in a particular country. And so particularly for a social networking platform like a Facebook that enforces a whole lot of house rules anyway, there is pretty strong incentive to just broaden the house rules so that you're not dealing with a bunch of minor differences in law and taking down one thing in Sweden and a different thing in Norway, or one thing in India and a different thing in Pakistan. So there's kind of a problematic intersection of state and private power there, where with enough government pressure, the private companies exercise their power to just more broadly prohibit more things. Another way that the sort of consolidation of power over speech in the hands of big private platforms relates to these international and cross-border law questions is that 10 years ago, if an Indonesian dissident blogger were sitting in London posting critiques of the Indonesian government would have very little leverage to get that taken down. Now, that blog is much more likely to sit on top of Medium or sit on top of Amazon Web Services, or in some way be dependent on infrastructure that belongs to a big multinational company that is vulnerable to pressure in Indonesia. And I'm in no way saying either of those two particular companies, would give in to the Indonesian pressure. Indeed, Medium resisted in almost exactly this fact pattern. The Malaysian government was coming after them, trying to get them to silence a dissident blogger in London. They refused to do it and they got blocked in Malaysia. But just the fact of the sort of multinational presence of the big companies creates much more risk that a government on the other side of the world can affect the speech that you see where you live. In terms of governments explicitly or implicitly reaching across borders and trying to get things taken down globally, Europe has been a real leader and Canada has been a real leader. So in the most important court case on this as of a couple of years ago was the Equistec case in the Canadian Supreme Court, which in full disclosure, I worked on for Google when I was at Google, which ordered Google to globally remove links to a particular business based on a trade secret dispute in Canada. That really started the ball rolling for other courts, including in defamation cases in India, to similarly assert their right to order global takedowns based on violations of national law. And in the past couple of years, we saw two cases from the EU's highest court, the Court of Justice of the European Union, that said this was okay, that said, not all the time, not as a matter of course, but some of the time, if courts think it's the right thing to do, they can order global takedowns for right to be forgotten claims and for defamation claims. Those were the issues in those two cases. So we see the sort of explicit intention to affect global speech or to assert authority to get global compliance based on national speech law. And then we also see fuzzier things. So the EU, the European Commission, negotiated something called the Hate Speech Code of Conduct with Microsoft, YouTube, Twitter, and Facebook, in which those four companies agreed to incorporate European hate speech law restrictions in their terms of service, so that European law flowed out to global enforcement not through an explicit act of a European court, not through a democratic or, constitutionally or human rights accountable process, but instead through this weird negotiation with private companies to then use their private power to change global speech rules in a way that that satisfied the demands of a government actor. So again, the sort of public-private power shifts are part of what makes this area so weird. We're used to thinking about governments as the main agents of censorship or pressure, and now we have platforms as channels that can enhance government power in troubling ways.
Understood. It's a very complex environment, and I know that I was surprised when we were doing our research to see how disproportionate the takedowns for under terms of service were as compared to takedowns in response to a government request. So that is where it's certainly in the automated area as well, where most of the action takes place.
Definitely. And, I will defend that to some extent. If Facebook weren't prohibiting bullying, pro-anorexia content, racism, all this stuff that's legal speech in the United States, it would be a horrible place to be. Nobody would like that version of Facebook. So it is what consumers want, generally speaking, but it also creates this point of leverage for governments.
Gotcha. Speaking of government leverage, maybe we could go to Russia. I'm wondering, Ali, if you could just give us a sort of pre-Ukraine, post-Ukraine, what are the sort of major elements of the Russian approach? And I know that's a great big question, and I'll ask you to maybe get us started. And then if Nigel and Daphne want to chime in, that would be great.
Yeah, I think we could spend all night talking about pre-Russia in the internet space. It's a great question and very important one given what's happening right now. So the way that I sort of see it is what we've seen over the past month has been long in the making. So Putin, Kremlin, and just the broader state has been placing the groundwork for isolating Russia from the international internet for years. And they've been doing this through a number of different tactics. So trying to go after actually changing the underlying infrastructure of the internet so they can sort of be walled off and have what they call the RUNET, passing these really repressive regulations so that then the internet looks the way they want it to, and strong-arming international tech companies to comply with those regulations. And then sort of fine-tuning the censorship apparatus. Russia has not always had the most sophisticated censorship situation, not anywhere near to what is the same in China or even like Iran. They've botched a lot of censorship attempts, like when they tried to block Telegram a few years ago, they just were very unsuccessful with it. People could still use it. But so that's sort of been happening over the past, I would say, decade or so, but it's accelerated. And then there's a sort of other component of it, and in trying to, sort of kick out or wall off international sources of information. At the same time, they've been trying to prop up these domestic social media alternatives to Facebook and Instagram and Twitter. And these platforms, VK being one of the biggest one, VKontakte, it's sort of a Facebook looking platform. It's owned in one of the other big platforms, Sneaky, my Russian, not good at all. Both of them, their parent company, are owned by Putin allies. So if you think about if there doesn't need to be a legal demand to remove content, when Putin allies own it, they can just take down what they don't want. And then also these platforms are more likely and more effectively complying with repressive domestic laws like data localization, having the local offices that some other international platforms have tried to resist. So that has all been happening for 5 or 10 years. So what's been going on the past month, not surprised by them at all. But what I have been surprised by is how dramatic they've been and how Putin's been able to more swiftly cut off Russians from the international internet in 1 month than I think he's been able to do for the past decade. Like, that's astonishing. And if you look at the blocking of Facebook, Twitter, and Instagram, that's a really clear escalation, given all the sort of struggled attempts the regulator has had at blocking Twitter previously. They tried, I think, last year or the year before. And one example too is like if you zoom in on just the blocking of Instagram, that was particularly surprising and really impactful because of so many people in the country have relied on that platform for their small businesses and like everyday livelihood. So when that was blocked, people were really upset. And the way Instagram is not used as much for political mobilization and how Facebook and Twitter was. So that's happening. And then there's this other element of sort of just the broader state media environment has just been on overdrive, which I don't think is a surprise to anybody here. And then you couple that with the new fake news law and how that law has then led to so many non-Russian news outlets either leaving the market or pulling reporters out of the country over fear of those criminal penalties. Then one other element I just want to bring up that we've been doing some work on at Freedom House and working with different civil society groups on it, is how democratic governments are rightfully taking sort of swift action to punish Putin and the Kremlin for what's happening in the EU, the US. But in doing so, we're really concerned that we're not careful enough in how we're deploying sanctions or how companies are complying with sanctions. And the risk of cutting off ordinary Russians from the global internet. And in doing that, inadvertently extending Putin's grip over the Russia's information network. So, limiting internet access only undermines people's attempts in the country to organize against the war, to report openly and honestly, and just access reliable information. So really concerned with international companies pulling out too swiftly, not doing due diligence, or just cutting people off altogether from really independent sources. And we signed a letter that went to President Biden that I can put in the chat where we talk about some of these things because I am not a sanctions expert, but some of my colleagues who know it more lay out some of the things we would want to see from companies who are thinking about how to comply, and also from policymakers who are imposing those sanctions.
That would be great. Please do put it in the chat. Nigel or Daphne, would you like to add anything? Or did she cover the landscape?
Ali did a great job of covering the landscape. I think it's just important to remember what happened in Russia is sort of like the culmination of a long time and a lot of different policies, and hopefully should serve as a lesson for Europe and the United States and others, not just about how do they look at, targeting, using sanctions to target both security and economic sort of connections with Russia and its actions, but then also positively, hopefully spurring action to define a framework of principles and rules and cooperation that they themselves and the firms that operate them can have a clear idea of how they each sort of look at things generally in the same sort of broader way. Because sanctions are a blunt tool, you can't just use them everywhere. And when we're talking about information and digital connectivity and digital trade, we have to be careful that. And so I would only hope that this spurs some more sort of creative thinking from the United States and others of like, okay, we need to get ahead of this issue in other countries before they get to where sort of Russia's at in being able to enact sort of switch off the internet, switch off the content providers, the social media networks, everything else, like shut things down in a worst case scenario, which Russia, like Putin, has obviously been planning for, knowing something like this was probably going to be happening. How do we get ahead of that before those countries sort of less further along the curve in terms of putting in place these types of policies to try and head off that? I just hope that's one of the reactions that we see that comes out of what's happened with Russia.
Daphne, did you want to add something?
Yeah, I mean, I 100% agree with that. And I think, if we're looking down the road to countries that are making legal changes going in an alarming direction, I would say, the number one country I would like the US to be paying more attention to is India, for the reasons that Ali discussed. I think Brazil belongs on that list also. And there are probably people here who understand better than I do what the US government can actually do, how USTR discussions or State Department messaging or, what the levers are to pull. But there is a real need for transatlantic cooperation. So I would call on European authorities here as well to push back on these problematic developments, but problematic is a very weak word there. I also just want to point out this, yesterday, the Washington Post ran an editorial, like not an op-ed, the editorial board speaking, urging YouTube to stay in Russia because that, to continue offering services, even in this situation where Google employees were threatened with arrest in the country, because YouTube has become such an important source for actual news or information to counter what Russians are seeing on television. And that's such an interesting development to me, because at the beginning of this conflict, I think a lot of people's starting assumption was that companies should pull out of Russia. And that might be true when you're looking at companies whose function there is economic, although that is also complicated. But when the function is to provide for the exchange of information, I think the Washington Post editorial board is completely right that wanting them to stay there is important. There's a professor at Yale who maintains a really interesting running list of which companies have pulled out of Russia. And the ones that haven't are listed under the heading of digging in. And one of the companies that they list is Cloudflare, which is an information infrastructure provider. Having Cloudflare up and running in Russia is valuable for the same reasons that having YouTube there is valuable. But I think that people who aren't used to looking at this through the lens of censorship and information policy, don't automatically see it that way.
Yeah, that's just to piggyback on that. Daphne's hit the nail on the head there. In a way, that's interesting that we would love to see the US government do this in a more considered way of who are we calling on to leave Russia and who are we calling on to stay, and what will we do to help those that we want to stay. And the State Department explicitly called out that we are calling on others to leave, but we want Cloudflare to stay because they provide an essential service to maintain connectivity and information with Russia. If the State Department was able to think about that a little more conceptually about, okay, for future scenarios, what can we do? How can we help indemnify these firms if they get targeted? How do we build action around that to support them doing what is in the longer term and for them really tricky, politically, economically tricky for Cloudflare to go, we're going to stay in Russia, to help provide that broader enabling framework for them to do that in Russia and in other scenarios.
Thank you. This conversation vis-a-vis Russia is so valuable and actually feeds into several of the questions that we received from the audience, which were about how to respond better to the increase in censorship, not just in Russia, but globally. I can't ask this question to Martha because the ITC doesn't make policy recommendations, but I would be interested in what you all think could be done by government policymakers, by tech companies themselves, by NGOs to really have a more robust and thoughtful response in the global censorship area. So whoever might want to start with that would be great.
I'll start then. I'll focus on governments just because, obviously firms have a role to play here, but I think there's been a particular lack of action and there's been a vacuum in terms of clear government policy that provides a clear direction and signals and support for firms to try and more often than not do the right thing in these tricky situations instead of leaving them there on their own to sort of defend US interests and values, which is in the face of the Chinese Communist Party it's going to be a losing battle. And so I hope, and that's why full credit to everyone at the ITC for this report. I hope this spurs some thinking in the context of what's happened with Russia, with the Biden administration's announcement of its alliance of democracies. Start to think about how do they work together to sort of talk about some of the guidelines and the rules and principles about supporting a mostly free and open internet and not just focusing on the content, but the processes behind it, so that which is a real part of it, in that firms need to have a better idea of what is required of them in a way that provides them for a chance to defend themselves, to have redress and stuff like that. The process is very important, as is the sort of the matter of making the point about the content. And we just haven't seen a clear articulation of that type of strategy by the US government or others. And so I think hopefully with your report and all the data and evidence that it puts forward, it can do that. The one point I think that starts that I referred to in one of my questions in the chat was a good place to start, which your report does, is transparency. Mandate, like setting up transparency measures to like identify and catalog these measures both domestically and then also when they happen extraterritorially. And that it sort of then forms the basis for us to look at, well, where is this happening? How often is it happening? Sort of what legal mechanisms is it being addressed through? And then how can we respond to that? And then would hopefully form the basis for broader cooperation, whether at, I don't know what the right forum, Daphne or Ali maybe have other suggestions. I'm a trade and economics folk, but a lot of these complicated, tricky digital issues often get put in under the OECD, in part because it's a small group of generally like-minded countries that are very technically, legally focused, where they can work towards principles and processes and frameworks that they can each then go home and apply in a way that is broadly consistent. But I realize this is a broader issue, but I'd be interested in what Daphne and Ali have to say about how, in an ideal world, if the EU and the US and others sort of were to get together at this, where would be the best place for them to do it, to try and push the ball down the field on this?
Daphne, please.
So I guess Nigel, I wish I had an answer about institutionally where this should sit, but I'm not going to pretend to. But my answer to the question of what governments should be doing, one thing in the long term is modeling the behavior that you're going to demand, from Russia. If your government is in the process of doing sort of shotgun blast takedown demands, which we're kind of seeing with the European Union telling platforms that they need to take down not just Sputnik and RT, but also users who post content from Sputnik and RT with no exceptions for discussion or criticism, et cetera. That is the kind of thing that we would definitely criticize if Russia were doing it. And I think we should also criticize when the European Union does it, with full respect and humility, toward what they're experiencing right now. They are sitting next to a war with a giant hostile nuclear power. And I can't imagine how scary that is or how much that makes trade-offs of human rights protections for security improvements or perceived security improvements seem worthwhile. But that puts you in a pretty bad negotiating position to try to tell the Russias or the Indias or the Brazils of the world to avoid doing those things themselves.
Ali, I think you're going to get the last word, actually.
Amazing. Yeah, I mean,
it's exciting.
Both Nigel and Daphne said, and on Daphne's example too, another example of that was President Trump's executive order around TikTok and WeChat, and resorting, instead of dealing with genuine privacy laws or privacy concerns through maybe a privacy law or something else, resorting to, let's just take them from the app stores, really normalizing censorship there from a democratic government. I'll go with something though very specific that we have come across in our Freedom on the Net research is strategic litigation from civil society groups. They've been pretty effective. I mean, not in every country. You need to obviously think about sort of the judicial independence, but in countries like we've tracked them in India, Pakistan, Sudan, Togo, Zimbabwe, where strategic litigation brought by civil society groups or their allies have actually reversed censorship decisions. So internet shutdown orders, a website block in Pakistan, shutdown order in Sudan. Society to think about. These cases can be really expensive and resource heavy. So this is where private sector can step in and help out, or governments, democratic governments, State Department, different foreign affair ministries in the EU fund a lot of these programs, or like public interest lawyers. That is like a very narrow recommendation that I think can have an effect and have a downstream effect, because then what happens is you'll see like civil society groups in Indonesia who brought a case about an internet shutdown in Papua, then working with civil society groups in other countries and sort of building resources and capacity to take these cases forward. Not always effective, but has worked repeatedly in recent years.
That's great. And what a great suggestion for this group of people interested in international law. So thank you for that. Any final comments? So many, but I guess Nigel, close us out.
I mean, this issue has been bubbling for some time. I can only hope that with this report and greater focus and attention to how individual jurisdictions manage this issue, and then obviously try and do it across jurisdiction, that this is added to the international agenda for greater engagement and cooperation. I think it's risen to that level. It hopefully has risen to that level. But obviously it's tricky because you're dealing with obviously different countries with different values and different legal systems, but there needs to be some concerted effort by generally like-minded countries, value-sharing countries, to try and get broadly on the same page amongst themselves to differentiate themselves. Otherwise, as Daphne said, like it's amazing how quickly some of these things translate from an own goal, in terms of like the Trump EO to ban TikTok and WeChat was used as justification by India to block 100 different apps. And it's just like one thing after the other. And so it doesn't take much. So hopefully this last year or so of seeing these types of incidents provides a foundation for, I don't know, clearer, more creative thinking around it going forward. Got to try and end on a positive note.
I was just going to say thank you for ending on a hopeful note. Thank you. Michael, do you have any close for us?
Yeah, what a terrific panel. Thank you to all the panelists. Thank you, Kate, for putting this together. I hope you stay connected with Washington Foreign Law Society, and maybe we'll have you on for updates at some point in the future. The panel will be online on the website in a couple of days, so folks can rewatch it if they want and watch it if they haven't. And we'll be posting all the interesting material that you shared in the chat on the webpage as well. So folks will have that available too. With that said, I'll close the panel. Thank you all for participating and have a great evening.
Thank you.
Thank you.
Thank you all.
Thanks.